Enough. One word. That's all it took. According to the official court transcript, one word from a judge who had finally reached his limit. The defense attorney froze mid-sentence. The gallery went silent and the cameras captured what legal analysts are calling the most important courtroom moment of the year. This is my courtroom, not a political rally, not a media circus. My courtroom. According to newly surfaced court records, the defense team had been pushing boundaries for weeks, testing limits, playing to the cameras instead of the jury. But on this day, this specific moment documented on page 247 of the transcript, the judge did something nobody expected. He took control, and he didn't apologize for it. So what pushed this judge over the edge? One moment, one decision, one line the defense should never have crossed. According to court filings dated just last week, the defense attorney stood up during a critical phase of testimony and launched into what witnesses described as a political speech, complete with references to outside investigations, media narratives, and what the transcript calls inflammatory characterizations that had nothing to do with the evidence at hand. But here's the thing. This wasn't random. This was weeks of boundary pushing, finally catching up. The documents show a pattern going back to the first pre-trial hearing, where the judge issued his first warning about courtroom conduct. The defense ignored it. The second warning came during jury selection. Ignored again. The third warning, documented in a sealed sidebar conversation now made public, included a specific threat. One more outburst and I will take action. And I'm going to show you exactly how it all fell apart. Filing by filing, warning by warning. The moment everyone's talking about, it's coming. But first, you need to see what the defense did to earn it. Because according to these records, this wasn't judicial overreach. This was a judge doing exactly what judges are supposed to do. Here's what actually happened the moment everyone clicked to see. Tuesday morning, 9:47 a.m., courtroom 4B. The air was already tense, according to multiple witnesses quoted in local court coverage. The prosecution had just finished presenting a key piece of forensic evidence, methodical professional by the book. Then the defense attorney stood up. According to the official transcript, he didn't address the evidence. He didn't challenge the method. Instead, he turned partially toward the gallery where cameras were positioned and began what the court record describes as an extended narrative statement. Your Honor, what we're witnessing here is part of a larger pattern. The judge's voice cut in immediately. Counselor, do you have an objection to the evidence presented? I'm laying foundation, Your Honor. You're laying something. It's not foundation. The gallery shifted uncomfortably. Court reporters noted audible reactions. The defense attorney continued anyway. That's when it happened. According to the transcript, page 247, lines 12 through 34, the defense attorney referenced ongoing investigations in other areas, suggested the prosecution was politically motivated, and used the phrase witch hunt 3 times in 90 seconds. The judge's gavel came down hard, once, twice, 3 times. Counselor, approach. Now, what happened at that sidebar is now part of the public record. The judge's words captured by the court reporter, I have warned you repeatedly. This is a court of law. We deal in evidence, testimony, and legal argument, not talking points, not sound bites, not whatever you're preparing for your press conference afterward. The defense attorney reportedly responded, Your Honor, I'm simply advocating for my client. The judge's response documented word for word, No, you're performing, and I'm done watching the show. Return to your table, address the evidence, or sit down. Those are your only options. The courtroom fell completely silent. According to witnesses, the defense attorney's face went pale. He stood frozen for about 4 seconds, an eternity in courtroom time. But here's what nobody saw coming, what the extended transcript reveals. The defense attorney didn't sit down, he doubled down. Your Honor, with respect, I believe the record should reflect the gavel again, harder this time. The record will reflect that you've been warned 4 times about conduct. The record will reflect that I've shown extraordinary patience, and the record will now reflect this. He leaned forward, every eye in the courtroom locked on him. This is my courtroom, not a political rally, not a campaign stop, not a television studio. You will conduct yourself as an officer of the court, or you will be held in contempt. There is no third option. There is no appeal from this warning. Am I absolutely clear? According to the transcript, the defense attorney responded with 2 words. Yes, Your Honor. He sat down. The prosecution resumed. Official records show the rest of that day's proceedings continued without further incident. No more speeches. No more references to outside investigations. No more playing the cameras. The judge had done in 90 seconds what weeks of warnings couldn't accomplish. He reminded everyone who controls a courtroom, if you're watching this thinking, finally a judge who actually maintains order, hit subscribe. Because this story has layers the headlines aren't covering. and I've got the court filings to prove every single claim I'm making here. But not everyone sees it that way. And honestly, their argument is stronger than you might think. The defense team and their supporters are calling this judicial overreach. Before you dismiss them, hear this out, because some of what they're saying actually checks out. One criminal defense attorney with 23 years of experience, not connected to this case, but commenting on the transcript, put it this way: zealous advocacy is not just allowed, it's required. Defense attorneys have an ethical duty to fight for their clients using every legal tool available. When a judge shuts down that advocacy, even if it feels excessive, we should all be concerned. Today it's this attorney, tomorrow it could be any of us. That's not nothing. That's a real point, backed by decades of legal precedent. Social media is split right down the middle. Thousands of comments say the judge was biased, that he's been harder on the defense than the prosecution throughout the trial, that this outburst shows his true feelings about the case. And here's where it gets uncomfortable for those celebrating the judge. According to court watchers who tracked the full trial, the prosecution has made similar boundary-pushing statements, references to the defendant's character, hints about other possible crimes, and received gentler corrections. One legal blogger documented 7 cases where prosecution overreach got a quiet sidebar instead of a public scolding. There's a pattern here. One defense side legal analyst noted, when you count the public warnings versus private corrections, there's a clear difference. That's the kind of thing appeals courts look at very closely. Even neutral observers, journalists who cover the trial daily, admit the judge may have been legally right, but the optics are complicated. Publicly dressing down defense counsel in front of cameras creates its own story. Some will see strength, others will see bias. The truth probably requires watching the full trial, not just this clip. Constitutional law scholars are raising a deeper question. One professor at a major law school, someone who has argued before appellate courts, offered this: judges have huge power to control their courtrooms. That's on purpose, but that power can become a weapon if used unevenly. The question isn't whether this judge can do what he did. Clearly he can. The question is whether he should, and whether he would do the same to the other side. So let me be clear about something. I'm not here to tell you who's right. Is this judge restoring order and protecting the fairness of the trial? Maybe the evidence supports that view. Or did he cross a line that scares real defense advocacy? That's also possible, and there's evidence for that view too. The truth is probably somewhere in the middle. And that's what makes this story so important to look at carefully. What I can tell you is what the documents actually show. And the documents show a pattern of growing conflict that was building toward this exact moment. This didn't come out of nowhere. 6 weeks before this blow-up, the warning signs were everywhere, written in pretrial motions and hearing transcripts. At the very first pretrial conference, the judge set what he called ground rules. According to the filing, he clearly banned speeches, political commentary, or references to things not in evidence. The defense filed an objection, denied. A former federal magistrate who reviewed the early transcript said something that should have been a wake-up call. This judge was drawing clear lines from day one. Any experienced attorney would see that as a signal. Push at your own risk. Did the defense listen? The record suggests they didn't. During jury selection, the defense attorney made with the transcript calls an extended statement about the political climate. The judge stopped him. Warning number 2. During opening statements, another boundary push. Another warning, this one sharper. Records show that every week the defense pushed a little harder. Every time they got a warning instead of consequences, until that Tuesday morning when they didn't. The pattern in the filings is clear. A judge trying to keep control, a defense team testing limits, and a crash that everyone should have seen coming. One courtroom observer who's covered trials for 15 years said it simply. This judge gave them more rope than most would. They chose to hang themselves with it. The stage was set. The defense just didn't realize they'd run out of warnings. Drop a like if you see where this was heading. The pattern in these documents is crystal clear, and we haven't even reached what happened after the judge's rebuke. That's where this story gets really interesting. And then it happened. Tuesday, 9:52 a.m., courtroom 4B, 5 minutes after the first morning of the day. According to the transcript, the gallery was still processing the judge's earlier words. The defense attorney had just returned to his seat. The prosecution was ready to call their next witness. Then the lead defense counsel stood up again. Your Honor, before we proceed, I need to make a record. The judge answered right away. You may make proper objections when appropriate. This is appropriate, Your Honor. I'm noting for the record that this court has consistently, the gavel. Counselor, I just explained this. Did you not hear me? I heard you, Your Honor, but my client has rights. Your client's rights are being protected by these proceedings. Your conduct is not protecting anyone. It's creating reversible error. Now sit down. The official transcript notes a 4-second pause. The defense attorney sat, but according to witnesses quoted in post-hearing coverage, his face showed something else: defiance, frustration, the look of someone who believed he was right and was being silenced. Then the judge spoke to the courtroom. Let me be clear for everyone here, including the media. This trial will be run under the rules of evidence and procedure, period. Anyone, and I mean anyone, who tries to turn this proceeding into something else will face consequences. There will be no more warnings, only actions. 17 seconds. That's all it took. 17 seconds to take full control so strong that, according to the rest of the day's transcript, not a single objection was raised for the next 3 hours. But here's what everyone missed while they focused on the drama. According to sidebar notes released later, the judge also told the prosecution this applies to both sides. Don't test me. Same warning to both sides. That detail didn't make the clips. Don't go anywhere. What I'm about to share changes how you should see this whole situation. Drop a comment. After hearing both sides, whose argument is stronger? The judge keeping order or the defense claiming overreach? Legal experts who study judicial conduct and trial rules are calling this a case study in courtroom control. One former federal district judge who handled high-profile cases for 18 years broke it down. What you're seeing is a judge who decided protecting the trial's fairness mattered more than avoiding controversy. That takes courage. Most judges give endless warnings to avoid media attention. He drew a line and held it. Let me say that in simple terms. Judges usually choose the easiest path. This one didn't. A criminal defense attorney with 20 years of federal court experience added something important. I've been on the receiving end of a judge's frustration. It's never comfortable. But reading this transcript, I can't say the defense didn't earn it. There's fighting hard for your client, and there's ignoring direct orders. Those are not the same. Here's what former prosecutors are saying privately. This sets a cultural example, not a legal one. Other judges are watching. Defense attorneys are watching. The message is clear. Political theater has limits in federal courtrooms. Some will cheer, others will worry. But it's not just one side. Civil liberties groups are weighing in too. We should always watch judicial power closely, but we also need courts to work. A trial where lawyers ignore the judge doesn't protect rights. It creates chaos. This balance is truly hard. A constitutional law professor from a top law school gave the most balanced view. The judge acted within his power. The defense acted within their rights to push back. Both can be true. What matters now is what an appeals court would say. If there is an appeal, that's where the real rule gets set. The legal consensus, and this is rare, seems to be that this judge walked a tightrope. Whether he made it across depends on who you ask. Smash the like button if this legal breakdown is helping you understand what's really at stake here. It's more than courtroom drama. It's about how our justice system works. Like if you want more analysis like this. So what does this actually mean for you? Right now, legal teams across the country are watching this case. According to legal news outlets, at least a dozen major trials are using similar tactics, playing to cameras, mentioning outside investigations, pushing political stories. But here's the key point. If you ever end up in court, this affects you directly. Here's how. The balance between strong lawyering and courtroom order decides whether you get a fair trial or a shell. If judges are too strict, your lawyer can't fight for you. If they're too loose, the other side turns court into a media event at your cost. Trials that turn into political theater last much longer. Studies show cases with serious attorney misconduct last about 40% longer on average. What does that mean for your money? Longer trials cost more for everyone, including taxpayers who pay for public defenders and courts. If you're ever in a civil case, every extra day in court costs you money. If you're a business owner, a landlord, or anyone who could end up in civil court, you should care a lot about court efficiency. Here's the bigger issue for all of us, no matter your politics. If this judge's style becomes normal, it means cleaner trials, but also more judge control over lawyers. Every time you hire a lawyer, the judge's style matters as much as your lawyer's skill. Here's a real example. Imagine you're wrongly accused. Your lawyer wants to explain the political reason you're being targeted. The judge says, "No, that's political speech." Now your defense is limited. That's not scare talk. That's the real effect of wider judicial power. I'm not giving legal advice, but here's what informed people think about. If you're ever on a jury in a big case, remember what happens in court is often very different from the news. If you're ever a party in a trial, ask your lawyer directly. What is this judge's reputation for courtroom control? Pay attention to judicial elections, because who sits on the bench decides how these balances work. And here's what most media won't say out loud. We want judges to control their courts until they control something we care about. Then we call it overreach. Think about it. If this judge had shut down a prosecutor giving political speeches, the same people angry now would be cheering, and vice versa. That double standard is the real problem in how we talk about judge power. If you care about fairness, you can't only care when it helps your side. Then the defense team spoke outside the courtroom and made things even messier. According to video from the courthouse steps taken within an hour of the session, the lead defense attorney held an unplanned press conference. Instead of calming things down, he escalated. What you saw today was not judicial authority, it was judicial activism. Our client is being denied his basic right to a strong defense. The public reaction was fast and split. The clip went viral. 3 million views in the first 12 hours. Comments turned into fights. But here's the worrying part. According to court filings sent in the next morning, the prosecution asked for penalties against the defense for trying the case in the media. The motion directly cited the press conference. The defense answered with a motion accusing the judge of bias and asking him to step aside. The judge's written response: motion denied. We will proceed, one legal analyst said. This is now a war. It's not about the evidence anymore. It's about who controls the story, and wars have victims. The prosecution's latest filing, sent just days ago, says the defense's public statements hurt the trial and show the same behavior the court already warned about. The defense replied, "We will not be silenced. Our client deserves a full and fair defense, not a muzzled one." This isn't ending. It's getting worse. The next hearing on these motions is set for next week. Here's what keeps bothering me after reading all the filings. Why did the defense push this hard on this day? The timing feels planned. According to the court calendar, a major procedural decision was expected that afternoon. Was this on purpose? Were they trying to trigger this reaction to build an appeal argument? Sources close to the case suggest the defense may be building a record for later relief, saying judge bias blocked a fair trial. The judge has set a closed-door meeting with both legal teams for next Tuesday. No cameras, no press. The topic, according to the schedule, case management and counsel conduct. What happens in that room stays sealed. At the same time, the defense hired a separate lawyer who specializes in claims against judges. Legal reporters say that's not something you do if you're trying to calm things down. The judges ordered all staff to send media questions to the court's public information office only. Something is happening under the surface. And based on the timing of these filings, both sides are ready for a much longer fight than the trial itself. The question is, who gives in first? Subscribe now because this story is far from finished. When those sealed hearing documents come out, I'll break them down. Turn on notifications. You'll want to see what happens next week. Here's where things stand now. As of today, the trial is still going. Both sides are still showing evidence, but the feeling in the courtroom, according to reporters who've been there every day, has completely changed. The defense is much more careful. Objections are short and technical. Political talk is gone, at least in court. The prosecution has also pulled back on certain descriptions. Whatever the judge said to both sides in private, it worked. Here's what's not in any official report yet. According to courthouse sources, and to be clear, this is not confirmed by documents. Both legal teams have met separately with court staff. No one knows what they discussed. Key dates ahead. Next Tuesday, closed-door hearing on counsel conduct. The following week, the prosecution is expected to finish its case. 2 weeks later, the defense case begins. Possibly 30 days from now, a verdict if there are no more delays. The jury has been told to avoid all media. Whether they are doing that is unknown. The clock is ticking toward a verdict, but the real story may come after. What keeps coming back to me is this. This judge drew a line most wouldn't. On the surface, it looks like proper use of judicial power. But stories like this rarely end the way we expect. If an appeals court sees bias, everything changes. If they see proper control, this judge becomes an example. If the defense's media plan works, public opinion shifts. If it fails, their client pays the price. The truth depends on which documents you read and how you read them. Is this judge a hero protecting courtroom rules or a barrier to strong defense? The answer could be both. It could be neither. The truth is still developing. No verdict has been reached on the case or on the judge's actions. What I can promise is this. I'll keep tracking the filings. I'll keep following what happens in that closed hearing next week. And I'll keep explaining what it means without telling you what to think. Subscribe if you want the full picture, not just viral clips. Notifications on because this case is teaching us something important about power, courts, and who really controls the story. I'll see you in the next one.